So welcome everybody. As I said before, it's lovely to see so many new, well, I'm going to say new faces, well, new names at the moment, but hopefully I can see faces as well as we go along. This is a collaboration between the Centre for Political Thought, and we normally hold a weekly reading group in the Centre for Political Thought on Wednesday lunchtimes. This is sort of a follow-up meeting to one that we had a few months ago, where a couple of colleagues from our Welcome Centre came over and visited us and spoke about loneliness. Charlotte and Fred did that, amongst others, as there's work on loneliness going, which crosses across both centres. So this is a kind of another opportunity for us to, as it were, have a joint meeting, and I'm so personally hopeful that we can do more of these, because I think there are some really nice areas of crossover between our work in the centre and, well, I say our work in the centre, and I realise since we're both centres, that's just going to get confusing, but there are crossovers between both centres. For those who don't know about the Centre for Political Thought, we've had a long tradition at the University of Exeter for doing research in history of political theory, history of political thought in its global context. And I guess that's still the main focus of our teaching and research focus. But as we've developed in more recent times, we have developed interests in climate change and intergenerational justice, in feminist theory and feminist practice, and also in participation, representation, and citizen empowerment. And I think all of these themes have points of connection with our Welcome Centre work. And this is a lovely opportunity with Chloe's own work to see how we can find these points of conjunction through sort of different ways in, as it were. So I'd like to introduce Chloé Deambrogio, who is at the moment a lecturer in criminology here at Exeter, but sadly only for a little bit longer, as I've just found out, as she's going back to Oxford soon, where she has a 3-year fellowship. So again, congratulations to you on that, Chloé. Chloé's got interests in themes of capital punishment, in mental health law, in gender and sexuality, and also in racial discrimination. She's currently working on 2 projects, a book which is based on her PhD thesis, exploring the development of psychiatric and legal concepts of mental illness and criminal responsibility in Texas capital cases over the 20th century, and another project in which he's undertaking a genealogical analysis of due process and anti-discrimination law in Texas, Georgia, and Alabama from the 60s to the present. And I'm assuming that work will inform at least some of what you're going to say in your presentation today, Chloé. So the presentation is called Constructing Mental Illness and Criminal Responsibility in Capital Cases, Psychiatric Expertise, Folk Psychology, and the Power of Stereotypes. Over to you, Chloé.
Very much, Robin, and good morning, everyone, and thank you to the Center for Political Thought and the Welcome Center for Cultures and Environments of Health at the University of Exeter for organizing this seminar. I'm going to share my screen because I have a PowerPoint presentation. So during this talk today, I will explore how medical and legal interpretations of human nature and behavior have contributed to the construction of specific understandings of mental illness and criminal responsibility in US death penalty cases, with a particular focus on Texas. The central concern of mental incapacity claims, the human mind, remains a mystery for both psychiatry and the law. Irrespective of their sophisticated theories, diagnostic techniques, and philosophical speculations, both disciplines have yet to find a way to fully understand it. Nevertheless, no other human mechanism plays such a central role in criminal trials. Defendants' reasoning processes, motivations, and feelings are essential for the establishment of criminal intent and have been so from the mid-19th century onwards. Due to their elusiveness and complexity, mental incapacity claims have historically triggered conflict, disagreement, and confusion. Situated at the intersection of psychiatry and the law, such claims raise problematic issues regarding subjectivity and criminal responsibility, whose symbolic significance extends beyond the specifics of individual cases. Solutions to issues of subjectivity and criminal responsibility depend on which view of human nature and behavior stakeholders endorse. Psychiatry and the law start from different philosophical assumptions. Correspondingly, they are historically divided on these issues. Criminal law doctrines are framed in the context of classical legal theory and Enlightenment notions of free will, which hold subjects morally accountable for their actions and require a proportionate response to lawbreaking tailored to the severity of the offense committed. In contrast, forensic psychiatry starts from 18th and 19th century positivistic assumptions and explains human behavior as a product of hereditary and physical traits, natural impulses, and environmental processes largely operating beyond the subject's control. From this perspective, a just response to criminality should start from a scientific investigation of the workings of the body and mind of the subject and take these evaluations into account in judicial determinations. The dialectic between philosophical notions of free will and scientific explanations of human behavior has vexed the legal system, the medical profession, and the wider public since its first manifestation in the 18th century to the present day. A cursory look at 20th century developments in mental health law and capital punishment jurisprudence seems to suggest that experts' role in the courtroom is expanding and that the law is increasingly engaging with the most advanced discoveries in the psychological and behavioral sciences. US Supreme Court rulings such as Woodson versus North Carolina and Ake versus Oklahoma have established the need for individualized considerations of defendants' background at sentencing and require the state to provide a psychiatric evaluation to indigent criminal defendants with alleged mental health issues. Key decisions such as Dobert versus Merrell Dow Pharmaceuticals have required courts to rely on modern standards of scientific validity and reliability in evaluating the potential admissibility of expert evidence. However, the analysis of 20th century death penalty cases reveals the existence of a deep mismatch between the law in the books and the law in practice. While the US Supreme Court has repeatedly attempted to incorporate the scientific discoveries and clinical expertise of the mental health professions, the lower courts have taken a backward and stagnant approach to mental disabilities and their bearing on defendants' moral culpability. In most low-profile cases tried over the 20th century, the input of experts was either missing or grounded in dubious or obsolete scientific standards, the quality of legal representation was below average, and the rulings of the higher courts were either ignored or distorted to fit local political agendas. With the exception of a few high-profile cases, if experts were called to testify, they rarely relied on the most recent advances in their field, revealing a wide gap between the pace of development of academic scholarship and its practical application in forensic contexts. Moreover, even in the few cases where highly qualified defense experts provided compelling evidence aimed at reducing the defendant's moral blameworthiness, the soundness of their scientific arguments and the accuracy of their conclusions ultimately did not seem to matter. As this presentation will show, rather than being dominated by scientific views of human psychology and behavior, trial proceedings and sentencing verdicts were powerfully informed by widespread common sense view, which routinely ignored the empirical evidence provided and deferred to prejudices about what mental disabilities are, how they manifest themselves, and how they relate to the crimes committed. In line with the United States' traditionally democratic and populist approach to legal matters, the trial courts have a tendency to privilege the view of ordinary men over that of experts and intellectual elites. This tendency emerges in courts' apparent efforts to maintain these common sense views intact by omitting clarifying instructions for the jury, allowing expert testimonies based on evidence that has been deemed inaccurate by legal and psychiatric authorities, and by directly fueling stereotypes through prosecutorial argument. This far from flattering picture shows that in order to fully understand how mental disability law is routinely applied and why it is applied in this manner, we should not limit ourselves to the analysis of US Supreme Court decisions and high-profile cases. Instead, we need to turn our attention to the hidden world of mental disability law, to the daily workings of the trial courts where the destinies of invisible defendants charged with capital offenses are ultimately written. Drawing from psycholegal theory, forensic psychiatric publications, Texas trial transcripts, and opinions by the Texas Court of Criminal Appeals, this presentation will explore this hidden world, focusing on the conflicts and misunderstandings which inform the interpretations of the intersection of mental illness and crime in 20th century capital cases. The reason for focusing on Texas is that this jurisdiction has historically played a central role in the American death penalty debate, both for its high execution rates and for its punitive approach towards mentally disabled capital defendants. The reasons for the mismatch between modern scientific principles and their application in the legal arena are varied. First, while the US Supreme Court has acknowledged the importance of giving effect to mental disability evidence in guilt and sentencing deliberations, it has repeatedly stressed that psychiatry and psychology are not exact sciences, and that the law is not bound by the criteria followed by the mental health professions. Secondly, the legal and the psychiatric view of human psychology and behavior are very different, creating an ontological and epistemological clash with a difficult, if not impossible, solution. Advocates of the common sense approach to human psychology in mental disability cases propose that all juries need to know about the defendant's mental state can be inferred without the contribution of mental health experts. Mental health professionals, on the other hand, hold clearly diverging views, highlighting the importance of expert knowledge for the understanding of the psychological mechanisms underlying the criminal act. Thirdly, science and the law start from a different notion of time. Whereas science constantly looks forward, legal opinions, even the most radical and innovative, are bound by historical precedent. While psychiatrists and psychologists always seek to replace old theories and methods with new models and techniques, judges and attorneys are required to justify their decisions with established jurisprudence. Even when trying to keep in line with scientific developments and current concerns, the legal system needs to ensure stability and continuity. The behavioral sciences, on the other hand, are not bound by the scientific beliefs of the past and would languish if constrained by what has already been said and done. This philosophical discrepancy is partially responsible for the ongoing tension between the legal and the scientific view of human psychology that dominates the psycholegal arena. Whereas science proceeds by paradigmatic shifts, the law is a product of gradual historical change, is mostly suspicious of the latest innovation and deferential to the status quo. While the law has maintained intact a folk psychological view of human behavior, whose origin dates back thousands of years, psychiatry, psychology, and neurophysiology have repeatedly challenged this view by unveiling the physiological mechanisms underlying our mental processes and proposing alternative explanations for the formation of criminal intent. The folk psychological view that informs mental disability law is a seemingly intuitive theory used by individuals to understand and predict their own and other people's behavior. As legal scholar Katrina Sifford explains, and I quote, "This cognitive capacity allows humans to postulate that behavior is causally related to mental states such as beliefs and desires, and to predict or interpret such behavior based on attribution of mental states." This folk psychological view is routinely used in the criminal law context to establish defendant's mental state at the time of the crime and the relative level of guilt. Sentencing verdicts thus depend on whether a defendant had the intent to kill, whether he believed that the act was wrong, or on whether the act was committed knowingly or purposefully. While recent discoveries in the field of neuroscience have provided new and compelling challenges to common sense explanations of behavior, these attacks have had little impact on the legal reasoning underlying the assignment of criminal culpability. Part of the explanation is that this view of human behavior is a necessary condition for the maintenance of the concept of responsibility upon which our legal system depends. If we did not assume that humans were rational agents guided by internal desires, and I quote legal philosopher Lelling here, it would be impossible to judge individuals against any kind of behavioral standard, since such standard would be undefinable. If human action was entirely directed by neurophysiological mechanisms, the concept of personal accountability would essentially lose any explanatory force. When trying to establish a defendant's sanity for legal purposes, most American states, including Texas, rely on some variation of the English McNaughton rules. The rules, developed in 1843, established that in order to be found not guilty by reason of insanity, The defendant must show that at the time of the alleged criminal act, he was so deranged that he did not know the nature and quality of his act, or that the act was wrong. However, research suggests that eminent members of the judiciary, state and federal legislatures, and members of the American public find the wild beast standard of insanity more convincing. Developed by Justice Tracy in 1724, the wild beast test embodies one of the most entrenched and widely held misconceptions about how mental illnesses leading to criminal exculpation should manifest themselves. According to the wild beast test, in order to be found not guilty by reason of insanity, and I quote, a defendant must be a man that is totally deprived of his understanding and memory, and doth not know what he is doing, no more than an infant, than a brute, or a wild beast. Such a one is never the object of punishment. The wild beast test prompts three considerations. First, by framing insane individual as a category whose mental powers are qualitatively rather than quantitatively different from those of normal individuals, Justice Tracy depicted the mentally disabled individual as different in kind, playing into an idea of abnormality that separates the mentally incapacitated from the average person. This approach plays into old and still widely held assumptions about the ontological character of mental illness at its intersection with crime. According to legal scholar Arlie Lonan, through its daily practices, the legal system has framed mental illness associated with criminal conduct as dispositional. By this term, she means that mental illness is viewed as a relatively permanent status or condition, which is inscribed into the character of the individual and results in particular antisocial and deviant behaviors. This idea seems to suggest a deep-seated tendency in the criminal law to frame mental illness as a mix of internal disposition and action, something inscribed into the character of the individual and interpretable in behavioral terms. The dispositional view of mental illness and crime reflects the fundamental attribution error described by social psychologists, a cognitive bias that leads humans to overestimate the influence of personal dispositions and to underestimate the impact of external circumstances on people's behavior. Texas district attorneys regularly take advantage of this tendency by inscribing defendants' actions into their personality makeup, often by exploiting psychiatric diagnoses such as psychopathy or an antisocial personality disorder, and by turning defendants' criminal acts into the totality of their persona, by essentializing them as rapists, murderers, sadists, thrill killers, or sexual predators, for example. Second, the wild beast test standard requires a complete lack of understanding and memory, an extremely high bar if we consider that even severely mentally disabled defendants usually maintain a part of their cognitive abilities intact. Indeed, far from resulting in beast-like behavior and a total lack of understanding and memory, mental illnesses and intellectual disabilities, even the most severe, rarely result in a total loss of the rational capacities. As explained by defense expert witnesses in the 2002 trial of John Penry, an intellectually disabled man charged with rape and murder, contrary to common misconceptions, and I quote here, you find people who can do some fairly sophisticated things that you wouldn't expect of a person with mental retardation. This isn't just the very bottom that people are like tree stumps or something, that they can't do anything at all. We know that there are strengths, we expect them, and it's included in the literature very strongly. Yet most people commonly assume that having strengths in some areas, whether practical or intellectual, is incompatible with the diagnosis of mental illness or intellectual disability, which should call for criminal exculpation. Prosecutors regularly play into this misunderstanding. They routinely undermine insanity mitigation claims by eliciting information from witnesses to the fact that the defendant does not behave irrationally in every sphere of life. A prosecutor choosing a similar strategy may ask the expert witness, and I quote, you say so-and-so is insane. Now, isn't it a fact that he dresses himself neatly every morning? He doesn't put his trousers on his arms and his coat on his legs, does he, doctor? When it is mealtime, he goes to the dining room. He doesn't go to the sitting room, does he? Psychiatrists have criticized this strategy, arguing that severely mentally ill defendants may still be able to provide food and shelter for themselves, go to work, and carry out other typical daily activities. Third, the wild beast test does not require the opinion of a medical expert, since even the average person knows what a child or an animal is. and hence can make the comparison based on his own observations. The idea that people without special medical expertise can rely on observations of defendants' manners, appearance, and behavior to establish the presence of mental disorder draws from widely held epistemological assumptions in the context of criminal law doctrines and everyday legal practices. As highlighted by Dr. Britton Evans, a former medical superintendent of the New Jersey State Hospital in 1909, and I quote here, "The average American citizen believes himself to be a standard authority on medical expert testimony. The testimony of medical experts furnishes the one theme which all men seem to be fully qualified to analyze, simplify, rearrange, boil down, or build up to meet individual fancy or personal prejudice." According to Lohnan, at its intersection with criminal behavior, mental illness is traditionally viewed as readable, meaning immediately recognizable even by a lay observer without medical expertise. Interestingly, this idea has resisted 2 centuries of attacks from the rising mental health professions, which have repeatedly highlighted the hidden and elusive character of mental disease and the need for specialized expertise for its diagnosis and interpretation. As clinical psychologist Timothy Durning testified at the Penrith trial, during his years of experience dealing with intellectual disabilities, he had encountered several myths and stereotypes. And I quote here, "Things like people with mental retardation look funny. They talk funny. They may have an odd speech pattern. It is an obvious disorder. You can kind of tell from across the street. Certainly, that's true of people with mental retardation. Some of those folks really do look very mentally retarded. You can see it. But many, many people don't look mentally retarded. They look like the rest of us. They don't dress any differently. They're interested in clothes and dressing stylishly and getting the latest jeans or sneakers or whatever. And so they will not appear mentally retarded." Despite psychiatrists' repeated challenges to these epistemological assumptions, the public continues to demand, and I quote Perlin here, that a mentally ill defendant comport with its visual images of craziness in order to qualify as insane. If a defendant does not look crazy, essentially, if rather than jumping on his chair, screaming to imaginary monsters, or running around naked, he sits calmly and quietly, his insanity defense is unlikely to be successful. The evidence coming from the medical world suggests that this common sense approach may be highly deceptive, especially since mentally ill and intellectually disabled people tend to mask the disabilities in an attempt to appear as normal as possible. The reliance on external appearance emerges clearly in the testimony of several lay witnesses in Texas capital punishment trials. Typical examples include witnesses commenting on the defendant's peculiar facial expression, wild eyes, and staring look, when arguing that, in their view, the defendant has gone mad. For instance, in the 1931 trial of Joe Shield, a man charged with the murder of his divorced wife and in-laws, a lay witness argued that before the criminal act, and I quote, "In talking of his family affairs and troubles, the defendant had a defiant look out of his eyes. Joe's expression was similar to the look on other fellows' faces who have proven that they were kind of wild by their later acts." The practice of asking experts to analyze the criminal act to infer defendant's mental state at the time of the crime constitutes an additional example of the law's tendency to infer mental health from the observation of behavior. In the first 3 quarters of the 20th century, this was done through the use of long hypothetical questions, which consist of hypothetical statements of facts upon which the expert is asked to base his opinion. More recently, it has become common practice to provide a reconstruction of the defendant's actions at the time of the crime and use them to establish whether they could result from a deranged or disabled mind. For example, at the 1950 trial of Richard McGee, a paranoid schizophrenic accused of murdering his fiancée's father, defense expert Dr. Paul White argued on cross-examination, and I quote, "The intention of getting away from the scene of the crime is indicative, in my opinion, of a man knowing the difference between right and wrong when he has killed a man. The defendant exercised some volition in getting away from there. He knew enough to think about it and believe that society would feel that he was wrong, and therefore he was fleeing from the wrath of society." Conversely, in the 1939 trial of Edward Wynne, the defense argued that the crime, murder to commit robbery, was irrationally executed, since the defendant did not attempt to hide from potential witnesses and was seen moving around the city in the hours following the killing with his trousers covered in blood. Coupled with the fact that Wynne was diagnosed with paranoid schizophrenia or dementia precox, and that he lacked a strong motive for committing the robbery since he was financially comfortable, according to the defense, Wynne's lack of concern about the blood on his clothing strongly suggested that he was insane at the time of the crime. Several medical experts have highlighted that using the facts of the crime as a test for insanity is unscientific and unreliable, and runs counter to well-established methods of identifying an individual's reasoning abilities. Nevertheless, this practice is extremely effective since it leverages the public's tendency to see the ability to premeditate a crime as being incompatible with severe mental disease, and expects, and I quote Perlin here, a type of impulse action on the part of the defendant who pleads insanity. A further misconception shared by the American judiciary and lay public is that mental illnesses caused by organic defects are a more legitimate exculpatory or mitigating evidence than those caused by emotional stressors, developmental problems, or other socio-psychological factors. The reasons for this tendency are twofold. First, the biological model of disease is seen as a legitimate source of knowledge because grounded in empirical physiological evidence, whereas socio-psychological explanations are seen as more abstract, less scientific, and therefore more dubious. People tend to have a materialistic bias and to question the very existence of mental disease if they cannot directly verify its presence through some form of visual aid. The invisibility of mental illness is troubling for most observers confronted with the question of whether they should exculpate criminal behavior. Hence their preference for objective evidence such as MRIs over personal accounts of symptoms coming from the defendant and mediated by the mental health expert. This tendency aligns with the anatomic pathological orientation of American psychiatry, which in its quest for the scientific objectivity usually attributed to other medical fields has gradually emptied the discipline from its psychological component and directed all its efforts to the analysis of brain physiology. Second, the biological notion of mental disease is the only one which relies exclusively on endogenous causes and is therefore more compatible with legal concepts of individual responsibility. Whereas in socio-psychological explanations, the blame can be distributed to significant figures of the defendant's life, traditionally the parents, in the biological paradigm, the source of the behavioral disorder is located inside the individual's body, making the assignment of moral blame to the individual more intuitive. Texas defense attorneys are acutely aware of the public's preference for biological over psychosocial explanations of criminal behavior, and therefore tend to privilege evidence capable of showing organic defects whenever possible. Prosecutors, on the other hand, seek to undermine such evidence and try to convince the jury that the defendant's mental illness is merely functional and therefore less legitimate. This despite the fact that there is no scientific evidence suggesting that mental illnesses originating from psychosocial stressors are less impairing than those caused by a biological condition. The outcomes of the trials reviewed for this study suggest that these commonly held misconceptions tend to militate against mercy in death penalty cases involving the mentally incapacitated. As we have seen, the folk psychological view of the criminal law tends to shape expert and lay interpretations of defendants' mental health, directing jurors' attention towards the defendant's external appearance and behavior, and creating an ontological association between the mentally ill defendant and the criminal act itself. Several other factors play an important role in supporting the imposition of death verdicts on the mentally incapacitated in Texas courts. Examples include the narrow cognitive focus of the Texas insanity defense and the widespread belief that mental illness is both incompatible with intelligence and easy to fake. My hope is that we will be able to address these and other themes during our group discussion. Thank you for listening.
Brilliant. Thank you, Chloe. That's just fascinating. So just before we open things up to questions and discussion, can I ask either of two ways of doing this? Please either type a question into the chat, or just a remark or an observation, and I think Dario is going to be monitoring the chat, so we call you chat monitor, Dario. But if you'd like to ask a question verbally, if you could use the raise hand function, if you click on the participants button at the bottom of the screen, and it brings up all the participants, there should be a button at the bottom there that allows you to raise your hand. If you can do that, and I'll try and keep an eye out for that. And if, when you're asking a question, if you're able to turn your camera on, that would be, I think it would be nice for Chloe to be able to see faces and for us to see everybody. But also, if you could possibly introduce yourself, because I think there are lots of people from different backgrounds in the university and outside here who we may not know. So it would be good to get to know you a little bit before you ask your question. So,
sorry,
yeah.
I mean, I think for raising the hands, you have to do reactions. At least in my screen, you do reactions at the bottom right.
Dario, that's because we're co-hosts and we don't have the raise hand function.
Okay.
But
Right.
we can use that. You can also use the reaction hand as well, but that doesn't stay up for so long.
Right, okay.
So yeah, any questions for Chloe? Any thoughts, any reflections, any feedback, any points of order? Dario.
I found it, the hand. Right, okay. So no, there were a couple of things. Perhaps I'll adjust. Well, one thing that I was thinking, of course, it's all the debate about the personal identity, you know, because also the philosophical thing, and that's just I was thinking, of course, you know, well, having worked on David Hume, I was thinking, of course, David Hume himself, when at the end of his treatise, thinks when he, in some way he tries to conclude all this kind of more skeptical discussion, which of course include a skeptical discussion of personal identity, and therefore, you know, we are not always the same person anyway. Therefore, what responsibility can we have? Of course, there is the famous kind of reflection of him working in the closet, in which, you know, he thinks all these thoughts, all these skeptical thoughts, but then, you know, he just goes out and plays, and then you know, whatever the game that he was playing, in which he works, you know, in some way he thinks as just a common man. So I mean, there is although of course it is true that you were saying that in some way the legal the law, the legal profession in some way may think in a kind of conservative, in a small c idea of science and so on and so forth. It's almost inevitable that, of course, in the law, you know, as the common society, let's say, we have to take certain kind of idea of responsibility, even if then the science. So I just wonder whether there is any kind of you know, this discussion also in the law about the question of our personal identity. That of course it's quite important. It's very difficult in a way just to do it. Then I got another question, but perhaps later. Okay.
I mean, I think the I don't know exactly what you mean by personal identity, but I think the legal kind of idea of personal identity is usually the rational subject who has you know, a will and directs it towards a choice, and there is usually a choice involved in every action that we do, and that's usually the image of human nature and identity, if you like, that is advanced by prosecutors usually in these proceedings. They always emphasize, you know, they always go through the facts of the crime over and over again, highlighting there was a choice here, there was a choice there, at this point there must have been a choice made. And again, they bring you always back to the analysis of what happened on that specific event. Whereas, you know, the scientific experts, the medical experts tend to try and expand the time frame to go back to so there is a more like a longer kind of assessment to a longer sense of identity, even in a sense, because it's the identity that has been developed over a lifetime. Whereas the criminal law approach is more to focus on a snapshot of that individual's life and you know, and in a sense, use that snapshot as a reflection of the identity of the individual. And expand it as if that was the totality of the persona. So I think in that sense, I don't know if that's what you meant by identity, but in a sense, that's what I would say. I would, yes, identify as the approach that is taken. Yeah.
Dario, you've muted yourself.
There is a question in the chat, but
yeah.
you know whether...
Chloé, Dave Taylor has who says he's a technologist. He has asked a really interesting question about the role of the judge in this situation and the extent to which the judge has a responsibility to direct the jury in such a way that he or she will based on the understanding, the interpretations could be misconstrued, so they can avoid or overlook these what he's calling gameplay, which is a nice way of framing it, I think.
Yeah, this is a very good question. So I would say that definitely the judge has the role of giving the instructions to the jury before they turn to the jury room and deliberate and decide on the sanity or insanity of the defendant or on the mitigation. But usually you wouldn't find in the jury instructions any kind of challenge to stereotypes about mental health. This kind of challenge usually now come from the defense attorneys who use the expert witnesses that they interview during the proceeding to challenge these misconceptions. And honestly, most of the trial is spent doing this nowadays, because given that we always have a jury of individuals who are not trained to recognize mental illness, a lot of the trial is dedicated really from the part of the defense to challenge these common sense views. But I would say that the judge's role is usually to provide the instructions to the law. So the judge will explain what insanity defense is, what the mitigation means, you know, all these more legal aspects of the proceeding. So that would be the role of the judge.
Okay, so, and in that sense, therefore, the use of scientific or arguments against scientific evidence would not technically fall under the remit of law as such. No, not really. I mean, ultimately, all legal standards are based on this folk psychological view, on this, you know, common sense understanding of behavior, and they're tailored on that. And in a sense, I think that that's a good thing. The problematic aspect that I see in this is that we don't really have, at least in the American framework, and at least in Texas in particular, in many states in the US, we don't have maybe a diminished responsibility defense, something that takes into account the nuanced nature of mental illness. So here we have an all or nothing approach. Either you're not culpable and therefore not guilty, and therefore we need a very strict and narrow standard, or you're guilty and you can either get a life without parole, which is an extremely severe punishment, or the death penalty. So we don't have really another kind of defense, another kind of standard to take into account the complexity of mental illness. Yes. Sure. Any other questions? And that people may want to ask Chloé.
Since my other question was following precisely what Chloé is saying, perhaps I can, I don't want to, you know, take the old time, but actually, yes, I understand, of course, that the research in particular is precisely on criminal law, capital punishment in Texas. And as you were saying, in these cases, even there is kind of, they don't seem to consider diminished responsibility. But in some way, maybe, I don't know if you looked also a bit more around about in the law in other kind of branches or in other kind of countries. Of course, if the issue is really to give such a drastic kind of punishment, well, capital punishment or even, or kind the life punishment. Of course, it is much more easy in some way to have a kind of black and white, and you get to decide really about this. So is instead the attitude, as far as you know, for other kind of punishment or for other kind of law, or in other countries where, of course, in some way there are no such drastic type of punishment, in some way more amenable to bring in the kind of development in the law. So, you know, also the degrees of punishment can be adjusted to the, of course, to the conditions. So is that something that...
Yes, absolutely. I mean, there are various variations also. I mean, there are various variations of the insanity defense as well. So this is very cognitive, you know, the cognitive also thinking about knowing right and wrong. So it's a cognitive approach. It doesn't take into account emotions, impulses, and all these aspects, which are taken into account in other jurisdictions and has been taken into account even in the United States in the past. So there have been various, you know, developments in this area. So for example, the irresistible impulse test is something that has been introduced in various jurisdictions and essentially take into account the idea that sometimes you might understand that an act is wrong, but your mental illness might prompt you to have some impulses that you have a strong difficulty to control. Certainly in general, you know, England has a diminished responsibility defense. Italy also has it. In the United States, you have something that can be maybe compared a little bit to it, which is the idea that if the defendant can show that due to a mental disease, he couldn't form criminal intent, he might be punished for a lesser offense, such as manslaughter. But it's not exactly the same as a diminished responsibility defense based on a consideration of emotions, impulses, and so forth. It's still very strictly cognitive as a criteria, and it's still very hard to prove. But yes, certainly, you know, for example, if one observes Italian trials, there is much more evidence of mental illness and much more nuance and different degrees of mental illness, which is presented. In death penalty cases in the US, you can, at the sentencing stage, because you have two different parts of the trial, a guilt stage in which you define the guilt, in which you can present the insanity defense, or a sentencing stage in which you have already proven that the defendant is guilty and you decide on punishment. At that stage, you can present mental illness, but only in death penalty cases. So if it's a murder that does not carry the risk of the death penalty, if you don't prove insanity, you're done. You don't have any other way to prove the presence of mental illness. So it's really a very limited number of cases that can be taken into account. So it's a peculiar thing of the American system, I would say.
Thanks, Dario and Chloé. I've got a question possibly from Michael Flexer. He was flashing on and off. I don't know if that means that he's visible or invisible, but Michael, do you want to dive in?
I'm visible, but not very audible because I've got a sore throat. Thank you for a fantastic presentation. Really, really brilliant and greatly interesting to hear. I work in the centre. I'm on the Waiting Times project, but my PhD was on representations of psychosis and a kind of a sort of semiotic account of the experiences of psychosis. And I've got, if it's all right, cheekily, I've got two very, very unrelated questions to ask. One, which is a kind of technical question about the legal system in Texas. I'm just curious to understand what kind of, how a successful version of the insanity defense can result in potentially maybe open-ended incarceration in a mental health facility, and what kind of, how that works there. So that was my first question. Maybe I'll ask that, and if there's time, I'll ask a second one.
Yes. So well, successful insanity defense would result in acquittal by reason of insanity and in hospitalization in an institution. Now, from what I know, there is a misconception that it's very easy that the defendant ends up in an institution and then gets released very quickly. There is no evidence to suggest that this is the case, but I think that probably there are assessments at a later stage to establish whether the defendant still lacks this cognitive understanding. But yes, usually they would be hospitalized in an institution and monitored, for that. That would be it essentially.
Fantastic, thanks. And I guess that does, if I've got the time to ask a second question, it kind of leads into this this kind of more sort of philosophical with a small p question that I've been teasing through myself a little bit in relation to Anders Breivik, the mass murdering Nazi, and really curious about his 2 different psychiatric reports that he got in relation to his mental state at the moment that he's committing the murders, and one finding that he was experiencing some kind of psychosis or paranoid schizophrenia, and the other saying that actually he was fully aware of the consequences of his action. He had an underlying narcissistic personality disorder, and part of the distinction between the 2 assessments, as I understood it, depended upon whether or not there really was a community of neo-Nazis called the Knights of the blah, 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 for whom the things that he thought as a motivation for his actions, whether they existed or not, and whether the things that he thought were considered by that group of people to be reasonable or not, because then it became a sort of shared set of beliefs rather than an internal kind of psychosis. And I find that absolutely fascinating, that essentially there was no, as I understood, there was no actual work done to really establish whether there were these group of people, but rather a judgment was made whether it seemed reasonable to validate the views as non-psychotic on the basis of being shared or not. And I just find that a fascinating kind of question, because it sort of precludes the possibility of a collective madness or a collective kind of insanity, because essentially as soon as there are other people validating it, it's no longer, you necessarily must know the consequences.
Yes, I think this is very interesting. There are 2 things I would say about this. The first one is that certainly I've encountered cases in which the prosecution to challenge a claim by the defense that the defendant, for example, suffers from some form of paranoid schizophrenia, would argue that because of some characteristic of the defendant, being he is a criminal, and in some cases even more problematic claims such as he is homosexual, things like that, he is actually persecuted. So it's true that everybody's after him. So he's not a paranoid schizophrenic. He's just talking about his reality. So I found these kind of arguments, which I always found quite shocking, but like that as a way of challenging a claim of paranoid schizophrenia. And the other point about collective psychosis, like in some cases, I found that that's actually now a recognized like the diagnosis, in a sense, like that when 2 individuals are experiencing a similar kind of delusion, because for example, we find this in couples who have perpetrated crimes together, who were both seeing the same things or experiencing the same voices, but were both, delusional. So I think that's certainly something that has now also been recognized in the psychiatric field, So yeah, this is what I would say on that.
Because I was sort of familiar with the kind of folie à deux having a sort of history in and psychiatric recognition, but is there's legal recognition in the
legal, I don't know. I mean, again, usually the psychiatrists, present a series of theories that they have for the explanation of the crime, and the legal system doesn't necessarily have to acknowledge the scientific validity of that at all. I mean, ultimately it's an adversarial system. One expert might say, this is what the science says, the other expert says the opposite, and ultimately it's up to the jurors to decide which one they believe the most. And to be honest, often it's not based on the quality of what is being said. It's based on other considerations, such as, that expert is paid this much money to come and testify, he's a hired gun, as it's being defined, or I didn't trust him. To be honest, sometimes you have much more much more convincing evidence on one side, but the other side wins anyways because of other reasons. Also, we have to consider that in death penalty cases, the jurors are particularly death prone because of the qualifying method, the way in which they're interviewed for the selection. The jury selection creates what is being defined as a death-prone jury. If you have any kind of doubt about the morality of the death penalty, you will be excluded. So, you know, we already have a sample of people who are more likely to sentence you to death. Yeah. Yeah, it's
Thank you. That's really interesting and horrible to hear about the Texas juries as well.
you know, it's really, you know, and that was one of the reasons I started this project, was to understand, like, how is it possible that in this state so many severely intellectually disabled or mentally ill defendants get the death penalty, not even get punished, like get this level of punishment. And yeah, so I try to develop various hypotheses and test them.
Chloé, can I just pick up what you've said right at the end there? And thanks for your question, Michael, and I hope you feel better soon. We've got a question in the chat from Jessica, which I think speaks to that last point you just made. And she says she supposes the situation's changed in the last 20 years. And she's wondering if that's the case and how that's the case, and how changes have happened, or what sorts of changes have happened.
Yes, certainly we do find important changes, and also in the quality of the presentation of the evidence and so forth. There have been some improvements because of a series also of Supreme Court decisions, which have really imposed higher standards of legal representation, imposed states to fund defense for indigent capital defendants, and also like stricter requirements for the presentation of mitigating evidence of mental illness. So we find much more information about the defendant's backgrounds, about their family relationships, which usually were not addressed at all over the 20th century. Usually was a very simplistic, descriptive approach in which we found like a label applied to the defendant, a description of the evaluation and the description of the symptoms, but really not a strong explanation of how the mental illness contributed to the criminal act, which kind of left this black box problem of not understanding, like, what's the link? Why does this matter? You know, why are you telling us all this? And that's quite important for the jury to be able to give effect to it. So I would say, yes, there is definitely improvements in the sense of like the quality and the quantity of information provided, which is more contextualized, more focused on, yes, the family and the community in which the defendant lives. At the same time, the standards, the legal standards, have remained the same. So the problems related to the narrowness of the insanity defense are still there. And ultimately, if the standard is very narrow, even if you give more information, that might not like make a huge difference ultimately in the outcome of the cases in this sense. So this is what I would say after that.
Jessica, is there anything, would you like to follow up on that at all? I'm going to take that as a no. Just you are on mute, so I didn't. But I think you shook your head. But is that right? Yeah. Okay.
You're on mute, Robin.
Oh. I have a couple of questions I'd like to ask Chloé, but I'm going to hold off just now while I try and be a competent chair. So anyone else want to ask any questions? Okay, so in the absence of hands for now, I had two questions, Chloé, I wanted to ask. The first is around evidence and in particular standards of evidence and the nature of evidence. I'm partly thinking about this because we have one of our so-called beacon projects in our Welcome Centre is around the nature of evidence, and in particular challenging norms of biomedical evidence, scientific evidence, what counts as evidence, and because our own approach in the Welcome Centre is to approach health and well-being using humanities and social science and arts approaches. And inevitably this raises questions about what counts as evidence and what evidence looks like. And it's intriguing to me that actually there are standards of legal evidence and standards of scientific evidence which are coming into conflict here. And in particular, that it might be presumed that there are standards of objectivity pertaining to scientific evidence which are different to and perhaps more rigorous, but I'll come back to that, than legal evidence. But it was striking to me that one of the things that you said is that there's a perception, or one of the tropes that's used is that psychology and psychiatry don't have the same sort of robustness of evidence or scientific status as perhaps others. So I'm interested to know to what extent you've reflected on the different types and natures and standards of evidence, and how you see those playing out in a kind of, if I would say this, in a sort of almost like a dialectic in the court, as you've been talking about it.
Absolutely. The courts have explicitly made a distinction between what they called hard sciences and soft sciences in defining the standards of admissibility. So, whereas the hard sciences have these specific standards of scientific reliability, validity, the standards have to be accepted in the community, in the scientific community. There is like a peer review almost process. There is a very strict methodologies to say, yes, this evidence is admissible. When it comes to what they call the soft sciences, meaning psychology, the behavioral sciences, they use them. Generally, there is a lower standards used. And in Texas in particular, they use what I would call like an experience standard, essentially meaning that any person who has a lot of experience in a specific field is considered to be a legitimate witness on these topics. And this is controversial because sometimes in Texas, we have some very famous examples. Psychologists, forensic psychologists or forensic psychiatrists who have testified in thousands of cases have been found to have who have been found to be problematic in terms of ethics. For example, there was a doctor called Dr. Death because he always testified for the prosecution and always argued that the defendant was a psychopath and was 100% certain that he would kill in the future, which is completely unscientific, obviously. And he, based on his experience alone, could be seen as a very reliable witness. Then, of course, he was also, fell in disrepute and things like that, and was, banished by the American Psychiatric Association and so forth. But this happened after 50 years of him doing this in the courtroom. So certainly there are very different standards because psychology and psychiatry are seen as being not completely sciences, so there's this more subjective element. And yes, it's been particularly problematic with regard to the future dangerousness prediction. Because this is a particularly controversial area that the American Psychiatric Association has deemed as being, has said essentially, we don't have particular expertise to predict this, at least until they created these actuarial methods, which are a bit better. But anyways, and this was ignored. The Supreme Court said, even if the APA says this, we use this method in many areas of the criminal justice system, so we believe that they are legitimate. And they essentially disregarded that. So there is often this conflict, yes, in that sense.
I think that the relation between that and this kind of outwardly visible, and the connection between the outwardly visible and what you call the materialistic, or kind of almost like a folk materialism and all that, I think is fascinating as a kind of way of thinking about objectivity. And it did make me think a little bit more, if I may ask, about this, Chloé. You talked about in your conclusion how there was almost a kind of a momentum, almost, or a confluence that builds up, which militates against mercy. And you talked a moment ago about death proneness as well in relation to that. Is there any correlation that you can point to, or that you suspect, or might there be any correlation to a wider lack of compassion towards mental illness more generally, and so that actually the connection here, is there some kind of correlation therefore between this militating against mercy to a kind of tendency to militate against compassion for those who are suffering mental illness in wider society, so that almost the court becomes a kind of reflection of this deeper sort of social determination in relation to phenomena of mental illness?
Yes, absolutely. I think there's been a lot of research even done by what's called the Capital Jury Project, which investigated also what jurors think when they're presented with mitigating evidence of mental illness and so forth. And I think one thing that comes up a lot is the sense that people might, many jurors would say stuff like, well, this defendant, they try to justify what he did by saying that he had problems in the family or mental health or things like that. But ultimately, many other people suffer these things and they don't kill anybody. So this kind of idea of, well, this is not sufficient to excuse the behavior. And so, yes, I think that there is this very kind of, I would say, simplistic way of seeing things, that, well, just because you did, even if you have this, you still could have resisted the temptation. You still could have stopped when even despite these problems. So certainly there is a general lack of compassion. And I think from a cultural perspective, certainly, the Texas and the American South more generally, there is a strong culture of law and order, the sense of individualism, of individual accountability is very strong there. And I think, I don't know, I think that in other cultures, there might be a little bit more sensitivity to this and a little bit more compassion in that sense. But certainly what I've found in all research on that area is that there seems to be a very striking lack of compassion. Yes, for sure. In that sense.
Fantastic, thank you. Any further questions for Chloé? Dario does have another question. Dario, do you want to dive in?
Well, no, it was in some ways a bit, it's not exactly about the topic of today's conversation, but in a way, well, one of the reasons when then he got in touch also as a center was because you mentioned also in the way, about your research, that you also take a kind of intellectual history approach. So I'm a bit curious about that. So I'm, unless there are other questions, I would like in some way, you don't have to, but I can see, of course, from your interest in reconstructing also historically the way in which the criminal system and the kind of the development both of the scientific discourse and the legal discourse, an intellectual history approach may be relevant. But I just want to hear from you, first of all, whether you are the only criminologist who got the intellectual history approach. Is there a kind of group, or because of course we certainly when we work in history of political thought, some of us in some way have been trained in a sense in what is normally called intellectual history. So there's that was a kind of curiosity, if you want, but yeah. I think it's relevant. So if you want to say something about that, would be interesting.
Yes. In this presentation today, I didn't get into like the more maybe detailed historical analysis that I did, for example, for my PhD, but there I was analyzing a lot like how the cultural and ideological context of different historical periods throughout the 20th century would influence the way in which mental health issues were framed in these trials and in the psychiatric literature. So in that sense, I speak about intellectual history in terms of like how cultural ideology and social changes would somehow impact this, in particular, like how cultural standards of behavior, hegemonic standards of masculinity, in my case, because all my sample was all male defendants. So how hegemonic standards of masculine behavior influence the way in which mental health issues were framed and things like that. I would say that generally criminologists tend to not do much history. And that's also why I wanted to do it, apart from my background being in history. So I kind of brought together these two disciplines in a sense. And I think that it would be good to create a better link between historians of criminal justice, historians of crime, and criminologists, because criminology tends to have a more sociological approach, which doesn't maybe take as much into account the historical aspects. But yes, I chose this approach because I feel like, especially when one takes some form of like constructivist approach to these apparently objective categories, history is very helpful in that sense, because we have some distance, we can look at things with the eyes like, oh, yeah, history helps in that sense because of this distance that we have. So, but yes, I would definitely say that historical approaches are a bit lacking in criminology in that sense.
But that's fascinating, if given what you said about this kind of temporal mismatch between a forward or future-facing science and a jurisprudence which always seeks standards in its past. Is that because are you suggesting that that turn to the past in jurisprudence is, if you like, non-theoretically sophisticated? It's just, here's a fact that's been established and we work with this, or here's a protocol in law that's been established without questioning the kind of wider historical determinants of that.
Yes, I think definitely there is an assumption even in the law to kind of have an idea of like fact and truth as being independent of these more historical backgrounds, and often that's a critique, you know, done by critical legal scholars, even to opinions which don't take into account, you know, broader patterns of oppression. For example, decisions related to the discrimination of African Americans, in which we have these legal decisions which take this colorblind approach, which doesn't take into account all the historical factors which play into these patterns of oppression and things like that. So certainly that is an important issue with legal reasoning, this kind of like detached from the context kind of way of thinking.
So you have, yeah, again, this sort of naivety about objectivity.
Yes.
It's just see it repeating and repeating, which is fascinating.
Yes.
Yeah, fabulous. Any other questions for Chloé? I'm looking for hands. And not
There's a long question.
Ah, yeah. Okay. Dara, so Chloé, I don't know if you can call that up, but so in the court case, should we be moving away from the tendency to judge whether someone is mentally ill based on behaviors that they exhibit that might be influenced by other factors? And then Jennifer carries on. I think of cases in social work where women of color, mostly Black, are deemed unfit mothers when their children are being taken away from them because they are crying and therefore hysterical. That's fascinating. And Jennifer then says, I'm training to be a psychotherapist. Can you speak to that, Chloé?
Well, I think, you know, external observation of behavior alone doesn't tell us much about what is going on in the mind of the individual. And I feel like that's often something that is being left out. And also some rules of trial proceedings as well make it difficult to really assess what is going on in the mind of the individual when they're doing these things. Apart from the fact that it's very rare to find somebody who doesn't understand that, for example, murdering somebody is wrong. I mean, this would be really a level of intellectual and mental problem that is almost impossible to find. And I mean, even a child who is not fully developed understands that maybe he's done something wrong, but that doesn't mean that we hold them fully accountable for what they've done, in a sense. So I feel like there is this idea which is controversial. And I think the problem is that often, for example, in these proceedings, we never hear the voice of the defendant. It's a trial strategy often done, you know, the defense prefers not to put them on the stand. But in some cases, it can also be helpful to hear directly the voice. I've seen some cases in which actually putting them on the stand was helpful because the jury could have a direct experience and hear the voice of the defendant. And sometimes these also led to exculpation. So I think the fact that the defendant's voice is always completely silenced or filtered by the mental health expert, we don't know exactly what was said during the session, how the questions were asked. Like it's a very, you know, they summarize an experience that they had with this individual, and we are often supposed to just believe what the defense expert says because they don't give us really much to work with. There aren't recordings of the interviews. There aren't like really the real words of the defendants barely come out, you know. So yes, I think that there are some problems really with identifying what is going on with the mind of the person rather than, and what we're left with is behavior. It's all we can base it on. So I think maybe by changing, like if we start from a different epistemological assumption, we will try to investigate more what's going on under the surface. That was a bit the case, a little bit more in the era of psychoanalysis, in which we, you know, there was an attempt in that direction, but I feel that that's also been put away in a sense. And maybe the good parts that came from that idea have also been put aside, you know, so.
Jennifer, did you want to follow up on that at all? Oh, okay. Thank you, Jennifer.
Thank you.
I was wondering in relation just to what you said right at the end there again, Chloe, if I may, just is how much of this is a consequence of adversarial law or the adversarial practice of law, where it seems a large part of the process is actually to call into question the reliability of witnesses, let's say, or the reliability of the evidence that they are presenting. Whereas in a system of law which isn't based on that adversarial approach, I could imagine a recourse to transcripts of interviews, for instance, and an examination of data would become something that would be possible. And actually that norms of availability of data in scientific, when we're making, for instance, doing peer review or whatever, might be something that would be accessible in a way that adversarial approaches don't allow for.
Yes, I think that there is a very different, a strong difference between, for example, inquisitorial and adversarial systems in that sense. Especially, yeah, for example, if you have an inquisitorial system in which the expert is court appointed, they can be like, neutral kind of, or at least, apparently neutral experts appointed by the court. So in that sense, the idea of, oh, you're a hired gun for the prosecution would not be maybe in the mix as a reasoning for the jury. I think one thing that strikes me often with the adversarial system is that no matter what comes up in the trial, the prosecutor is going to go for the harshest sentence. And I find that to be interesting because in the inquisitorial system, if the prosecutor identifies, for example, an issue, like they might also ask for a lower punishment. So that, I think, yeah, I found that to be problematic in that sense. Advocates of the adversarial system would disagree, but I think that there is some issues in that. Yeah.
Okay, thank you, Chloe. Any final questions? Any last thoughts, or anything that anybody wants to contribute as we draw to a close? Okay, I think, Chloe, if it's okay with you, I think we can maybe round this up. I can just thank you so much for a really, really interesting presentation and a very interesting discussion, which has raised so many issues which actually touch on the work of both centres. And I do hope that we'll be able to keep in conversation, even if more and more distance comes between us. I do have a final question, though, before we finish. I'm fascinated. What's the painting behind you? It looks amazing.
It's an Indian piece of art. I don't know exactly. It's not mine.
Okay. Oh, well, thanks very much. And if we can give a sort of virtual round of applause to Chloe, that was thanks for a great session. Thank you, Chloe.